Good day, everyone. I am Michelle Sabasaje and I am your reporter for today. My first topic is all about the duties and responsibilities of owners, developers of subdivision and condominium project under PD 957. So first is the mortgage. Under Section 18, no mortgage on any unit or lot shall be made by the owner or developer without prior written approval of the authority. Such approval shall not be granted unless it is shown that the proceeds of the mortgage loan shall be used for the development of the condominium or subdivision project. An effective measure has been provided to ensure such utilization. The loan value of each lot or unit covered by the mortgage shall be determined and the buyer thereof, if any, shall be notified before the release of the directly to the mortgage, who shall apply the payments of the corresponding mortgage indebtedness secured by the particular lot or unit being paid for, with a view of enabling said buyer to obtain title over the lot or unit promptly after full payment thereto. And next is the advertisement. Under Section 19, advertisement that may be made by the owner or developer through newspaper, radio, television, leaflets, circular, or any other forms about the subdivision or the condominium or its operation or activities must reflect the real facts and must be presented in such manner that will not tend to mislead or deceive the public. The owner or developer shall answerable and liable for facilities, improvement, infrastructure, or other forms of development represented or promised in the brochures, advertisement, and other sales propaganda disseminated by the owner or developer at his agent, and the same shall form part of the sales warranties enforceable against said owner or developer jointly and severally. Failure to comply with these warranties shall also be punishable in accordance with the penalties provided for in this decree. So next is time of completion. Under Section 20, every owner or developer shall construct and provide the facilities, improvements, infrastructures, and other forms of development, including water supply and lighting facilities, which are offered and indicated in the approved subdivision or condominium plans, brochure, prospectus, printed matters, letters, or any form of advertisement within 1 year from the date of the issuance of the license for the subdivision or condominium project or such other period of time as may be fixed by the authority. And next is the alternation of plan. Under Section 22, no owner or developer shall change or alter the roads, open spaces, infrastructure, facilities for public use, and or other forms of subdivision development as contained in the approved subdivision plan and or represented in its advertisement, without the permission of the authority and the written conformity or consent of the duly organized homeowners association, or in the absence of the latter by the majority of the lot buyers in the subdivision. So next is a non-forfeiture of payments. Under Section 23, no installment payments made by a buyer in a subdivision or a condominium project for the lot or unit he constructed to buy shall be forfeited in a favor of the owner or developer when the buyer, after due notice to the owner or developer, desists from further payment due to the failure of the owner or developer to develop the subdivision or condominium project according to the approved plans and within the time limit for complying with the same. Such buyer may, at his option, be reimbursed the total amount paid including the amortization interest but excluding the delinquency interest with interest thereon at the legal rate. So next is the issuance of title. Under Section 25, the owner or developer shall deliver the title of the lot or unit to the buyer upon full payment of the lot or unit. No fee, except those required for the registration of the deeds of sale, and the registry of deeds shall be collected for the issuance of such title. In the event of mortgage over the lot or unit is outstanding at the same time of the issuance of the title to the buyer, the owner or developer shall redeem the mortgage or the corresponding portion thereof within 6 months from such issuance in order that the title over any fully paid lot or unit be secured and delivered to the buyer in accordance herewith. So next is the donation of open spaces. Under Section 31 as ended by PD 1216, the registered owner or developer of the subdivision or condominium project upon completion of the development of said project may at his option convey by the way of donation the roads and open spaces found within the project to the city or municipality wherein the project is located. Upon acceptance of the donation by the city or municipality concerned, no portion of the area donated shall be thereafter be converted to any other purpose or purposes unless after hearing the proposed conversion is approved by the authority. And next is the organization of the Homeowners Association. Under Section 31, the owner of the developer of a subdivision project or condominium project shall initiate the organization of the Homeowners Association among the buyers and the residents of the project for the purpose of promoting and protecting their mutual interest and assist in their community development. So next is the realty taxes payment. Under Section 26, real estate tax and assessment on a lot or unit shall be paid by the owner or developer without recourse to the buyer for as long as the title has not passed the buyer. However, that if the buyer has actually taken possession of and occupied the lot or unit, he shall be liable to the owner or developer for such tax and assessment effective the year following such taking of the possession and occupancy. And lastly is other charges. Under Section 27, no owner or developer shall levy upon any lot or buyer a fee for an alleged community benefit. Fees to the finance service for the common comfort, security, and sanitation may be collected only by a properly organized homeowner association and only with the consent of a majority of the lot or unit buyers actually residing in the subdivision or condominium project. And let's proceed to the revised rules and regulation to govern advertisement approval HLURD Board, Risk Number 808 Series of 2007. First is the scope of application. These rules and regulations shall apply to all application for advertisement approval for the following project issued certificate of registration and license to sell, hereinafter referred to collectively as project. So this includes the residential, commercial, condominium, and subdivision, farmlot subdivision, industrial subdivision, memorial park, columbarium project, or any other similar project. Advertisement as referred to in these rules shall mean any form of information dissemination, whether through words, illustration, skill models for public display, or any forms of multimedia under Section 1. And next is the advertisement approval. Approval of the advertisement is required prior to its distribution, display, and or publication broadcast under Section 2. So next is the content of advertisement. The following shall be indicated or reflected in the advertisement. The exact location of the in terms of distance from a well-known references point, the license to sell number and date issued, project completion date per approved work program, maximum selling price in case of economic and socialized housing project, the names of the owner, developer of the project, the pictures or illustration, if any, shall be captioned as actual photograph as the case may be under Section 5. What should not be included in the advertisement? So the following shall not be included in the advertisement under Section 6. These are disclaimers, any future development not conveyed by the license to sell, and exaggeration of misleading information. Next is the advertisement approval. The board shall issue the advertisement approval when all the requirements of Section 46 are complied with. The approval shall consist of the letter from the HLURB or the regional officer stating approval of the advertisement material and authority to publish, display, distribute, or announce the same, and further stating therein all other conditions as may be imposed. The letter of approval and the approved copy of the advertisement material shall in all instances bear the HLURB seal. Further, the letter shall be stamped, approved, indicating date and duly signed by the regional officers. Any deviation from the approved contents of the advertisement material shall be a violation of the condition of the approval and a ground for revocation and approval under Section 7. And next is warranties. The owner or developer shall be answerable and liable for the facilities, improvement, infrastructure, or other forms of development represented or promised in the brochure, advertisement, and other sale propaganda disseminated by the owner or developer or his agent, and the same shall form part of the sale warranties enforceable against said owner or developer jointly and severally. Failure to comply with these warranties shall be also punishable in accordance with the penalties provided for PD 957. And now, let's proceed to the rules and regulation on the conversion of agricultural land to non-agricultural uses. DAR Administration Order Number 01 Series of 2002. The legal basis of this are Republic Act 6657 or the Comprehensive Agrarian Reform Law of 1987, and also the Republic Act 8435, the Agricultural and Modern Fisheries Modernization. With the governing policies, preservation of agricultural land to ensure food security, provide all economic sectors and all regions optimum opportunity to maximize agricultural productivity. Conversion shall be strictly regulated and allow only according to the Republic Act 6657 and Republic Act 8435. Agricultural land to be converted to non-agricultural uses. Agricultural land to be converted to another type of agricultural activities such as livestock, poultry, and fish pond, the effect of which is to exempt the land for Comprehensive Agrarian Reform Program or CARP. Agricultural land to be converted to non-agricultural use other than previously agricultural land reclassified to non-agricultural uses by the LGU after June 15, 1988. So how may apply? Owners of private agricultural lands or other person duly authorized by the landowners, beneficiaries of the Agrarian Reform Program after the lapse of 5 years from award reckoned from the date of issuance of the Certificate of Land Ownership Award or CLOA, with fully paid obligation and qualified to apply government agencies, including government-owned or controlled corporations, LGUs, owners of agricultural land as patrimonial property. Priority development areas for convention. In accordance with Republic Act 7916, EO-124 of 1993 and EO-258 of 2000. First is the specific areas in regional agri-industrial centers or the regional industrial centers identified by the Department of Trade and Industry and Department of Agriculture pursuant to EO-124 of 1993. Second is the tourism development areas identified by the Department of Tourism pursuant to the EO-124 of 1993. And third is agricultural areas intended for eco-zone projects endorsed by the Philippine Economic Zone Authority or PIZA pursuant to Republic Act 7916. Fourth is the agricultural land owned by the government to be converted for the project of national interest as certified by a proper government agency. Next is the agricultural land proposed to be developed as sites for processing plants of agricultural products as certified by the Department of Agriculture. And lastly is the sites identified for telecommunication facilities endorsed by the National Telecommunication Housing projects. In case of mixed use of housing project and non-housing projects, the application shall not enjoy the privilege of housing projects unless at least 80% of land applied for conversion shall be used directly and exclusively for housing. housing projects. In case of mixed use of housing project and non-housing projects, the application shall not enjoy the privilege of housing projects unless at least 80% of land applied for conversion shall be used directly and exclusively for housing. Areas non-negotiable for conversion. Land within protective areas designated under the NEPAS or the National Integrated Protection System, including Musi and the Virgin Forest, riverbanks, swamp forests, or marshlands. All the irrigated lands are delineated by the DA and or NIA where water is available to support rice and gum production or the Department of Agriculture or the National Irrigation Authority. All irrigated land where water is not available for rice and corn production but are within areas programmed for irrigation facility by DE or the NIA. All irrigable lands already covered by the irrigation project with firm funding commitment as delineated by DA or NIA, all agricultural land with irrigation facilities. Areas highly restricted for conversion. Irrigable lands not covered by irrigation project with firm funding commitment. Agro-industrial croplands or lands represently planted to industrial crops that support the economic viability of existing agricultural infrastructure and agro-based enterprises. Highlands or areas located in elevation of 500 meters or above the potential for growing semi-temperate and usually high-value crops. Land used with notice of land valuation and acquisition or subject of a perfective agreement between the landowner and the beneficiaries under the voluntary land transfer or direct payment scheme under the CARP. Environmentally critical areas as determined by the DENR in accordance with the law. And let's proceed to the Homeowners Association. Jurisdiction of Homeowners Association is now under the Housing Land Use and the Regulatory Board or the HLURB. First is the Statement of Policy. It is a policy of the Housing and Land Use Regulatory Board to establish and maintain a system that shall facilitate the processing of application for registration, filing of amended articles of incorporation and or bylaws, dissolution, and enrollment of the Homeowners Association and issuance of certification and certified true copies. So next is the scope. This policy applies to all application for registration, filing of amended articles of incorporation or bylaws, filing of dissolution, enrollment and request of certificates, and certified true copies submitted to this office for evaluation and approval. Next is objectives. To effectively implement Section 26 of Republic Act No. 8763, transferring to the Housing and Land Use Regulatory Board the power, authorities, and responsibilities vested in the Home Insurance and Guarantee Corporation with respect to Homeowners Association under Republic Act No. 580 as amended by Executive Order No. 535 Series of 1979 and Housing and Land Use Regulatory Board Resolution No. R-771 Series of 2002. Next is the guidelines. All applications shall be filed with the Homeowners Association Franchising and Adjudications Unit located at the ground floor Homeowners Association Building, GLURB Compound, Kalayaan Avenue Corner, Mayaman Street, Diliman, Quezon City, or at the respective regional office who has jurisdiction over the concerned association. Only application with complete and collated requirements shall be accepted for processing. An approval is granted to an application when it is complete, in oppose and in accordance with the law and the HLURB rules and on recognition and the supervision of the Homeowners Association, issuance of a certificate of registration, filing of amended articles of incorporation and or bylaws, dissolution, enrollment of certification and certified true copies shall be upon payments of the prescribed fees. Documentary requirements for the issuance of the Homeowners Association Certificate of Incorporation or filing of bylaws. First is the Article of Incorporation. This is signed by all 5 to 15 incorporators on every page. Second is bylaws, signed by all 5 to 15 incorporators on every page, if filed with the articles of majority of the members of the association and duly certified by the majority of the directors and countersigned by the secretary, if filed within 1 month after the issuance of certificate of incorporation. Third is the notarized written undertaking by the incorporators to change the corporate name in the event that another person, firm, or entity has acquired prior to the use of said name or some similar to it, and to comply with all the rules and regulation of the HLURB. Fourth is the notarized information sheet. Contains the names of the association, principal office address, list of the board of directors and trustees and their address, list of the officers and their position. And fifth is a notarized list of members of the association, a complete list of the members of the association. Next is a notarized certification as to the existence or absence of the HOA in the subdivision, territorial jurisdiction of the HOA, name and address of the nearest existing HOA. Next is a notarized authorization, written authority of the incorporators for the representative of the association to transact of follow-up and the application with the HLURB. And lastly is the approved subdivision plan for regular subdivision. There are also additional requirements for self-housing project undertaken under the Group Land Acquisition and Development or GLAD Community Mortgage Program or CMP or other similar land tenurial assistance program. First is the location and vicinity of the project, whether on-site or off-site, duly signed and certified by the geodetic engineer or surveyor. Second is a notarized list of officers and members, stating that the nature of the occupancy, whether as owner or tenants. Third is the transfer of certificate of title, certified true copy of the TCT from the Register of Deeds issued not later than 30 days before the date of application. And lastly is the letter to intent to sell, contract to sell, or deed of absolute sale or memorandum of agreement duplicate original notarized copies. Notes that such other documentary requirements as may be imposed by the Housing and the Land Use Regulatory Board or HLURB. Non-holding or postponement of regular or special membership meeting of election, executed by the Secretary of Board of Directors and attested to by the President. The following documents are admitted within 5 days from the date of the scheduled meeting or election in case a regular or special membership meeting or election is not held or is postponed. First is the notice of postponement of the regular or special membership meeting. Second is affidavit of non-holding of regular membership meeting stating valid reason therefore. And lastly is affidavit of non-holding of regular election stating categorically the reason why no regular election were conducted in accordance with the provision of the association bylaws. Let's proceed to the Presidential Decree number 957, the Subdivision and a Condominium Buyers Protective Decree. Under Section 2, when used in this decree, the following terms shall, unless the context otherwise indicates, have the following prospective meanings. First is a person. Person shall mean a natural or a juridical person. A juridical person refers to a business firm, whether a corporation, a partnership, cooperative or association, or a single proprietorship. Second is a sale or seal. Sale or seal shall include every disposition or attempt to dispose for a valuable consideration of a subdivision lot, including the building and other improvement thereon, if any, a subdivision project or a condominium unit in a condominium project. Sale or seal shall also include a contract to sale, a contractor purchase and sale, an exchange, an attempt to sale, an option to sale or purchase, a solicitation of a sale, or an offer to sell directly or by an agent or otherwise. Under with the Section 5 license to sell, such owner of dealers to whom has been issued a registration certificate shall not, however, be authorized to sell any subdivision lot or condominium unit in the registered project unless he shall have first obtained a license to sell the project within 2 weeks from the registration of such project. The authority, upon proper application, therefore, shall issue to such owner or dealers of the registered project a license to sell the project if after examination statement filed by the said owner or dealers and all the pertinent documents attached thereto, he is convinced that the owner or dealer is good repute, that his business is financially stable, and that proposed sale of the subdivision of lots or condominium units to the public would not be fraudulent. Next is the Section 6 or the performance bond. No license to sell subdivision lots or condominium units shall be issued by the authority under Section 5 of this decree unless the owner or dealer shall have the filed and adequate performance bond approved by the said authority to guarantee the construction and maintenance of the roads, gutters, drainage, sewerage, water system, lighting system, and full development of the subdivision project or the condominium project, and the compliance of by the owner or dealer with applicable laws and regulation. So the performance bond shall be executed in favor of Republic of the Philippines and shall authorize the authority to use the proceeds thereof for the purposes of its undertaking in case of forfeiture as provided in this decree. Under with the Section 7 or exempt transaction, a license to sell and performance bond shall not be required in any of the following transaction: sale of the subdivision lot resulting from the partition of the land among co-owners and co-heirs, sales of or transfer of a subdivision lot by the original purchaser thereof and any subsequent sale of the lot, sale of the subdivision lot or a condominium unit by or for the account of a mortgage in the ordinary course of business when necessary to liquidate and benefice debt. Next is the Section 8, suspension of license to sell. Upon verified complaint filed by a buyer of a subdivision lot or a condominium unit or any interest party, the authority may in its discretion immediately suspend the owner's or dealer's license to sell pending investigation and hearing of the case as provided in Section 13. The authority may suspend the license to sell if in its opinion any information in the registration statement filed by the owners or dealers has to become misleading, incorrect, inadequate, or incomplete, or the sale or offering for the sale of the subdivision or condominium project may work or tend to work a fraud upon prospective buyers. So the suspension order may lifted if after notice and hearing, the authority is convinced that the registration statement is accurate or that any deficiency therein has been corrected or supplemented or that the sale to the public of the subdivision or condominium project will neither be fraudulent nor result in fraud. It shall also be lifted upon dismissal of the complaint of lack of legal basis until the final entry of an order of suspension, the suspension of the right to sell the project, though binding upon all persons notified thereof, shall be deemed confidential unless it shall appear that the order of suspension has in meantime been violated. Next is Section 9, revocation of registration certificate and license to sell. The authority may or upon verified complaint filed by a buyers of a subdivision lot of a condominium unit, revoke the registration of any subdivision project or a condominium project, and a license to sell any subdivision lot or a condominium unit in said project by issuing an order to this effect, with his finding in respect thereto, if upon examination into the affairs of the owners or dealers during hearing as provided for in Section 14 hereof, it shall appear there is satisfactory evidence that the said owners or dealers is insolvent or has violated any of a provision of this decree or any applicable rules or regulation of the authority or any undertaking of its performance bond, or has been or engaged or is about to engage in fraudulent transaction, or has made by Any misinterpretation in any prospectus, brochures, circular, or other literature about the subdivision project or condominium project that has been distributed to prospective buyers or is of a bad business repute or does not conduct his business in accordance with law or sound business principles. Were the owner or dealer in a partnership or corporation or an incorporated association, it shall be sufficient cause of cancellation of its registration certificate and its license to sell if any member of such partnership or any officer or directors of such corporation or association has been guilty or act or omission which would be cause for refusing or revoking the registration of an individual dealers, brokers, or salesman as provided in Section 11 hereof. That would be all for my report. Thank you for listening and I hope you learned something and have a good day.